Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings.
All right. Amazon click activity.
Judge, this issue really ties into what we've just been discussing and I think is illustrative of the problem. So when motions in limine were due, we had notified the court that we didn't have expert disclosures on opinions on Shane Cox, who was going to be their Amazon expert, and Michael Douglas, who they had listed also as having information about Amazon. So when we raised the issue with the court about incomplete disclosures, like Ms. Taylor was talking about, we still didn't have those at the time that it was time to file a motion in limine. So our motions in limine. So the motion in limine related to Amazon Click and Amazon Records has to do with a lack of disclosure. When we filed the motion in limine on Amazon Records, we then got supplemental disclosures on Shane Cox and Agent Douglas, but not with any opinions.
Are they expert opinions or witnesses, or are they just fact witnesses to say, here's what the Amazon records show?
Well, I'm going to explain why it falls under expert opinion and what we've come to learn in trying to figure out what this data is. And I'll
there may be some rebuttal stuff in there based on your disclosures in terms of why the Amazon data, as I understand it, you're saying shouldn't be relied upon or admissible because AI made me do it.
Well, I think it's a broader explanation than that. But the issue is that we had received this data and without expert opinions to explain what the state intended to do with it, it left us in a spot of trying to figure that out.
How was it vague what they were trying to do with the Amazon records? It was pretty facially evident what the relevance of those
They're
were.
not facially evident, Judge. We have an Excel file that has a ton of names with metadata, and then we have what is known as an Amazon click packet that the state has produced, we think from Shane Cox, that has a sheet that talks about specific purchases that include the knife, include things like the gift card that you were just talking about, but without any context. And our hope was that with expert disclosures, we would understand, was there going to be testimony from them that somehow there was information on computer searches, specifically from computer examination, or the context of what metadata might explain about the ClickPay documents that they got. We now have some information because we have got an Amazon expert who has explained to us what we have and what we are missing. Obviously, the evidence is important to the state's case related to the Amazon information. And given the court's direction about its intention for us to call experts today, which Mr. Howell is available, we went ahead and submitted a declaration when the court said that you were disinclined to allow testimony, and we sought leave, but we didn't get a solid answer. So you've now got an affidavit in front of you, declaration.
Typically in motions in limine, I'm not being in a position to make factual credibility findings and the like, and so the testimony on paper is more than adequate to guide the court.
Okay, I appreciate that. So I'm going to explain then what the basis is for where we're at. The other issue that of course the court knows is that we sought to seek suppression of the Amazon records because the warrants were extremely broad. We expected to be getting significant data or have data that we hadn't let yet reviewed. The court denied that suppression issue. And so what we know that we have now is the list that I explained, but it's without metadata. And so for the purposes of what we've got going on here, there is, pursuant to Rule 106, a whole level of context that's really important to the Amazon data. And it's not just AI technology. It has to do with machine learning. And I think a lot of this is something that
AI.
Pardon?
Isn't that AI, machine learning?
I think that machine learning, I'm definitely not an expert on this, Judge, but I've provided you with a declaration. And if you want me to put Mr. Howell on to testify about
That's
the
not
difference
important.
between, he's far more articulate at it than I am. It's a combination of both with what happens with Amazon, because in terms of machine learning, one component is that when there's a household account where there's multiple users with multiple cell phones and multiple laptops going into purchases, there's machine learning and cross references there. In terms of the way that Amazon works as a company globally and artificial intelligence, they're doing all kinds of things to understand what consumers and purchasers and sellers are trying to do to actually prompt people to buy certain things. So in this instance, with regard to these purchases, we have very limited data regarding Mr. Kohberger's purchases without the metadata and the context. And that's the reason that we are seeking to exclude it. Now,
You got what they got, right?
Not really, because what we have is we know that they're going to draw conclusions and that they're going to draw conclusions about intent, but the way that they presented it to us in data is that this relates to Amazon clicks. Well, Amazon clicks makes it sound like to me and you, someone goes on and actually, with a mouse, clicks, opens a document, takes it into a cart, purchase it, and it's a much broader term than that.
And the state's testimony from their person who will testify that this is what the Amazon data shows, is that Amazon data shows that Mr. Kohberger, or at least his name, purchased the knife sheath and cleaning thing, knife sharpening, equipment, and looked as anybody who orders on Amazon does. Where's it at in delivery? And then later on that same account, after the homicides, looked at knives again. Now, I understand the defense's position and evidence and expert to be that, well, that's a shared account and anybody could have done that on that shared account. I don't know that that's a matter of exclusion, though. Isn't that a matter of just impeachment and cross-examination and your own experts?
That if the court doesn't exclude it, then that would be the remedy and the approach that we would take.
Would it ever be the remedy of exclusion?
Judge, if you don't exclude it, then that would be the alternative, I guess.
On what basis would I have to exclude it?
I started with that we did not have expert opinions at the time when we had to file a motion in limine regarding this data. And it's misleading that the way that you just portray it, that because there is a purchase in a household account, that is automatically attributable to him, and that there's somehow
a purchase
intent.
in a household account. It's attributable under his particular name in the account, as I understand it. Now, could somebody else in the family get to it? I don't know. I suppose your expert will tell us that. But I'm not sure how that is excluded, and I'm not sure how that's expert testimony. I understand you have an expert to say, well, all these other factors come into play and all these other things could have happened, and okay, you can put that on, but I'm not sure why that excludes the state's evidence.
Well, it would be extremely misleading given the declaration that we've put before the court about everything that goes into the way that Amazon functions.
You're asking me to be the fact finder again. I mean,
I'm not asking you to be the fact finder. I'm telling you that when we don't have complete disclosures and we're playing a guessing game of what this information means, and we have deadlines where we have to file motions, then we end up in this circular situation right now, right? Because we had to file a motion about this without knowing what the opinions are and what we're lacking in data. Now I have an expert who's explaining it. We've asked you to exclude it. You're indicating you don't think it's an expert opinion. And so then the next logical step would be our expert comes in and we're allowed to confront the evidence. But you also just proffered that, that based on the information that you understand, that equates to a purchase. And I've put a declaration in front of you from an expert that says that Amazon doesn't work exactly that way. And that's the problem, that when it is represented as a click, that indicates to the average person that he sat at a desk and clicked and made a purchase when there's a lot more to them.
and maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase. Am I wrong about that?
No, that is a step, but how it gets in your cart and what items get in your cart really has to do with the whole model and the ecosystem of the way that Amazon works, right? And so the state wants to apply in an argument. They will apply intent to purchase a K-bar to get to November 13th, 2022.
The evidence to argue at closing arguments.
But we still have to have testimony that explains those things in between.
Welcome to put on testimony that implies that Mr. Kohberger was not the one that hit purchase, or that he purchased it for a benign event, or that here's the knife, I have it. I don't know.
And based on what you're saying, that the Mr. Cox you think is a lay witness, then I'm assuming that also extends to him not being able to testify beyond what the disclosure is as a lay witness and no other opinions, and including Agent Douglas, who's given us no opinions whatsoever.
I don't know what they're going to say beyond that. And if they say something beyond that is an expert opinion that hasn't been disclosed, then the state's going to have a problem with it.
Okay. That's why we're having these arguments, Judge. They take a lot of work. It takes a lot of energy. It keeps us from 68 terabytes of evidence. Well, if everybody would just disclose, we wouldn't be having this back and forth.
The problem is you view it as a more complex issue than the state does.
Because it is.
Well, that's not their worldview. Okay? And that's the factual dispute that the jury gets to decide.
So what we're trying to do is make sure that their myopic worldview is what they're held to, because there is a much bigger picture to this evidence. Okay.
Judge, this is pretty simple. Shane Cox and Mike Douglas, since he gets brought up, they're fact witnesses. They're not going to have opinions. They review records. They're going to testify to what those records show. Shane Cox's testimony is laid out in the supplemental amended disclosure. This is exactly what he's going to testify to. And what he's going to say, he's very careful in what he says that he's going to say. That's what we're anticipating. There is no grounds to exclude his testimony. We applied for and we were granted a search warrant for Brian Kohberger's Amazon.com user activity. The search warrant was narrow in scope to items related to the homicide and evidence related to the seizing of knives. In this case, it was knives and knife accessories. It directed law enforcement to see certain items: his customer click activity pertaining to knives and accessories, his payment methods used, details of items in cart, including all items added to the cart or removed from the cart or wish listed or in a shopping basket, all suggestions made to the account, all records regarding reviews by other Amazon users, advertising data, devices used to connect to the account, and all accounts linked to the account. The state requested the data between limited time periods, March 20th to March 30th, and November 1st to December 6th. Those were the relevant time periods. And in response, we got responsive data, and that's what we plan on presenting to the jury. Amazon's use of AI is not a basis to exclude, and it's completely irrelevant. AI doesn't click on things for a user. There are no legal grounds to exclude this. We ask that you deny their motion. Thank you.
Thank you. So I think there's a fundamental, just different worldview as to the relevance and impact of the Amazon data. And the defense is entitled to challenge the data in terms of, does it really show who bought it? What else did they buy? In what circumstances? I understand the state's not really going down that apart from what the data shows, which is the purchases that have been laid out in the report. If the state tries to go beyond that without having disclosed those, or without a rebuttal disclosure to some of the things the defense has disclosed on that, they're not going to be allowed to testify to it. But there's not a ground for exclusion, because you have an expert that thinks that the evidence can be explained in a different way. That's just simply a fact determination for the jury based upon the conflicting evidence. All right, let's take 10 minutes and then we'll see if we can't bring this home.